The Honorable Justices of the Supreme Court. This court, from recess, now sitting.
Please be seated. Call the third case on the morning docket, 104198 and 104765, State of Kansas versus Eric Hurd.
Christina Curls of the Appellate Defender Office for Mr. Hurd. I'd like to focus my argument on the first issue of the brief, possibly touch on the fifth if there's time, but then submit the rest of the issues on the brief unless there are questions about it. And the first issue on the brief deals with the motion for arrest of judgment that Mr. Hurd filed. It is our contention that the state omitted an essential element of the crime that it attempted to charge. It is clear based upon the state's arguments at closing argument and the evidence that they presented that the crime that they actually intended to charge Mr. Hurd with was failing to register with the Seward County Sheriff's Department within 10 days of residing there. But the crime that they actually charged, and in fact the crime that was still charged in the Fourth Amendment amended complaint, is failing to file a change of address.
To win on this count, or this issue though, don't you have to establish that they didn't charge a crime, any crime? Does it matter that they charged a different crime than they intended to prove, at least for purposes of this motion to arrest judgment?
Well, based upon the case law that I reviewed, the exact language from the case law that I reviewed was that the information omits one or more of the essential elements of the crime it attempts to charge. And it's clear in this case that the crime that they were attempting to charge was failing to register in Seward County within 10 days of arriving, but not failing to give either Oklahoma or the KBI or Seward County notice of their change of address within.
They omit an element of that second crime, though, of failing to give the KBI or Oklahoma or Seward County a change of address.
They did not omit an element of that crime, but they did omit the essential element of the crime that they were actually attempting to charge.
So why isn't this a sufficiency of the evidence issue, or the second issue, the prejudice from amendment, rather than a motion to arrest judgment?
I filed it under a motion to filed the issue as a motion to arrest judgment, partially because that was what was filed in the district court, but additionally because the interpretation, what the case law said, that it omits an essential element of the crime that it attempted to charge. And it was clear in this case that the state attempted to charge offender registration violation under subsection A rather than subsection B. And we would argue that that still omits an essential element of the crime it attempted to charge. But then there was also, as you said, the issue with allowing them to amend. And we would also argue that even the amended complaint still didn't comport with the crime that they attempted to charge. In the amended complaint, they did not amend it to state that Mr. Hurd failed to register in Seward County within 10 days of moving there. It was that he failed to notify Seward County of his change of address within 10 days. And the difference being there, and the difference that was important in this case, is that Mr. Hurd was previously registered in Seward County. He was registered in Seward County in 2008. So technically, it wasn't alleged that when he moved from Seward County to Oklahoma, he failed to provide Seward County with that change of address. That wasn't what was alleged. It was alleged that when he supposedly moved back to Seward County, he didn't re-register. He didn't register. So even the amended complaint, the fourth amended complaint that they filed after all of the evidence had been presented, after the instructions conference, still did not state that Mr. Hurd committed an offender registration violation because he failed to register. That wasn't the crime that they charged, but that was the crime that they were arguing. That's the crime that they stated he had committed in the closing argument.
What if we agree with your position on the motion for arrest from judgment? What's the remedy?
The conviction's reversed.
And what's your basis for suggesting that?
It's the case I cited in my brief. That may not be the correct way to.
Yeah, I know
Pronounce
the
it.
case you're speaking
But
of. Okay.
in that case, it does specifically say a conviction based upon such an information, which is defective under the pre-Hall standard, must be reversed. And
Has he been placed in double jeopardy if we don't reverse the conviction?
I'm sorry.
Would he be placed in double jeopardy if we don't reverse the conviction? If we just agree that the motion should have been granted and essentially it starts over again?
I believe he would, because the state had the opportunity to charge it correctly the first time. The state could have charged it correctly. The state could have charged him with, I guess my argument would be is that if they wanted to charge him under both subsections, if they wanted to charge him with failing to register in Seward County and failing to notify the last place of residence within 10 days, they could have done both of those in the alternative, or however they chose to do. They had the opportunity to charge it correctly the first time, and they did not do so. So it would be our contention that he would be placed in jeopardy if they attempted to go back and...
But you don't have any jeopardy on a defective complaint. The pre-Hall law was that if you're missing an essential element, the court has no jurisdiction to convict of that crime, and we have plenty of cases that say if there isn't any jurisdiction, then jeopardy hadn't attached.
I guess the argument that I would make then, is because I hadn't necessarily prepared for the double jeopardy argument prior to coming, but just off what I know about it is if crimes could be joined in the complaint to begin with, if they could have been charged or they should have been charged in the complaint to begin with, and they can't go back and add something after they didn't get the conviction that they wanted. And I realize in this case they did get a conviction, but it's an invalid conviction because it was jurisdictionally defective. I mean, technically they could have charged under both subsections because it stands to reason, and the evidence did indicate that he didn't give notice to Oklahoma that he was changing his address, because part of his defense was that he wasn't changing his address, that he was just up in Liberal in the area to look for jobs and to put in applications to move his probation. So I guess my argument on that, just having not really unfortunately anticipated the double jeopardy thing, would be that they could have charged it, and now because they didn't charge it correctly, and because there are two crimes that could have been joined and should have been joined at the time, it would be unfair to Mr. Hurd for to go back and give them a second bite at the apple, so to speak, when it was their mistake in the way that they charged the crime to begin with. And then just to briefly touch on the second issue, since that's since Justice Luker brought that up, in this case, what the district court, after Mr. Hurd pointed out in the instructions conference, Mr. Hurd objected to the instruction that they wanted to give, that failure to notify Seward County of the change of address, or failure to notify Seward County that he was residing in Seward County. He objected to that because that wasn't the way that the crime was charged, and that wasn't what he was based his defense on. Because his defense was based upon the fact that he was charged with failing to notify Oklahoma that his address had changed, failing to notify the county that he resided in Oklahoma that his address had changed, and that wasn't necessary because he hadn't actually moved. The notice that he was given, the notice that he as a pro se litigant prepared his defense upon, was charging him with failing to give Seward County, or failing to give the last place of residence notice of his change of address. It was only after all of the evidence was presented and the case was getting ready to go to the jury that they changed that at the last minute, and we would argue that that did substantially prejudice him.
How is that? Was there any evidence he admitted that he would not have admitted, or was there evidence that he would have added had he known that to be the charge?
See,
we don't have any of that in the record, do we?
And I mean, yeah, we don't have any of that in the record, and that's part of the prejudice. I mean, he was a pro se litigant. He was representing himself. Part of the reason the Court of Appeals denied relief on this issue is because this pro se litigant couldn't, off the top of his head, figure out what type of evidence he would have admitted if he had been charged with something completely different.
Isn't that the danger? I mean, isn't that part of the cautionary instructions that the court gives to any pro se litigant, that's the inherent danger, is that you're not a lawyer, you don't understand the rules of evidence, and that's part of the risk that you take when you when you proceed pro se.
I mean, I do agree that there was a risk that he took when he proceeded pro se, but I mean, the pure and simple fact is that he was given notice that he was being charged with offender registration violation for failing to tell Oklahoma he was changing his address, and then before the closing arguments, that charge changed. The charge was failing to notify Seward County. It was completely different. My argument would be the same regardless of whether or not he was represented by an attorney or not. It was still prejudicial to him. Now, an attorney might...
Your argument that the statute says that the late amendment can be allowed so long as it doesn't charge a different crime.
So long as it doesn't, it's so long as it doesn't charge a different crime and does not substantially prejudice.
Your argument here is that the amendment charged a different crime.
It did. It still charged offender registration, but it was a different type of offender registration. And essentially, I guess my biggest problem with the Court of Appeals reasoning on this is, along with the rest of judgment and this, is that it essentially requires a defendant to be prepared and ready to defend against and anticipate all possible ways that he could violate the offender registration requirements. And I mean, we know that there are a lot of requirements for a defendant to actually comply with the offender registration violation, and he should be able to rely upon the notice that he is given as to how the state is claiming that he violated the offender registration violation when he goes to trial. The state should not be able to just change it so long as it still falls into one of the things that he may or may not have done to comply with the offender registration violation. He should be able to know what he has to defend against at the beginning.
The Fourth Amendment complaint did have it right in the sense that it did make it clear he was to notify the Seward County Sheriff's Office. Isn't that right?
It made it clear that it was the Seward County Sheriff's Office, but it was still the language.
Well, the language
from
was
subsection
within
B.
10 days of the offender coming into any county in which the offender resides or is temporary domicile. That's the language of the statute that he was charged with, where the complaint said basically within any change of address within 10 days of change. So it referred to a change of address, which was what you're saying is incorrect.
Yeah,
Isn't
it
that
referred
right?
to a change of address rather than the failure to register.
But under both sections, there's a 10-day period. And really, aren't they both talking about a change of address, whether you notify your prior registration location or you notify the new location? They're both saying within 10 days you need to let them know. Isn't the effect essentially the same? And how did his evidence change that he would have had to put on either way? Show he essentially he hadn't changed his address.
I guess this is a little bit more difficult considering the fact that, which kind of goes into my fifth issue, that he didn't really have the opportunity to put on the evidence that he wanted to because they moved up his trial date a month and a half on him. But so I don't know exactly what evidence.
That's a different issue, though. I mean,
I know, but I'm trying to answer your question in the sense that he wanted to subpoena different witnesses. One of those witnesses he said that he was going to subpoena was a probation officer he was working with in Garden City who actually went to his father's house and found that he wasn't actually living there.
essentially that he hadn't changed his address.
That he hadn't changed his address.
Which is what the other section is about, too. A change of address.
I understand your reasoning that they are definitely similar, and I think in this case it's difficult to point to the exactly what evidence would have been different because he wasn't notified. He wasn't given the notification when he was preparing his defense that he would have to defend against whether or not he provided Seward County with, whether or not he failed to register in Seward County. His defense was that he hadn't moved. If it was an issue of him if they had actually charged him, I'm trying to phrase this in a way that actually makes sense. If they had actually charged him with failing to register, he would have been able to provide evidence that he actually was registered in Oklahoma. And that could have been different evidence that what he would have provided that he never actually moved. Because there is, I don't think it actually came out in trial, but
well, it isn't a failure to register in Oklahoma isn't the section that he was charged with. It's the failure to notify Oklahoma that he had changed his address. That's the other section, A, I guess it is.
Right,
A1.
but his defense was based upon that. His defense was based upon the idea that he hadn't ever actually moved from Oklahoma, and that
Right.
so there was no need to give notification to Oklahoma.
And you're saying that that evidence would somehow have been different than the evidence he would have put on to show that he hadn't moved to Seward County?
I think it.
Because that's really what the difference is.
I mean,
and so was required to give Seward County notice under Section A2.
I think that. I mean, there definitely would be an overlap in evidence. I can't stand here and tell you exactly what the different evidence would be. Partly because, as the Court of Appeals stated, he did not explain what that evidence was. But at the same time, I don't believe that he should be penalized because he couldn't stand there off the top of his head just a few minutes or however long prior to going into closing argument and come up with an entirely different case theory, is I guess the point that I was trying to make. It appears that I am out of time. Unless the court has other questions, I would just ask the court to reverse the rulings of the District Court and the Court of Appeals.
Do we have any questions of counsel? Thank you, counsel.
Thank you.
Justice Stewart informed me that there was no appearance by opposing counsel, so that concludes the presentation of the case. We will take this matter under advisement.